Hello, my name is Edison Sergei Titus from the Titus Law Firm. Today we're going to be talking a little bit about breach of contract. Who is this for? This is for anybody who engages in business or has to sign a contract. And that really is everybody. A contract is any sort of agreement between one or more parties. Now, we're talking about breach of contract specifically, which is a civil cause of action. Civil cause of action is something that you go to the courts with the judge and you say, hey, this other party did this thing, and this thing that they did fits this cause of action. I have a cause to take action against them. Really, you're employing the court to take that action against them. So I have a cause for the court to take action against them. In this case, it's breach of contract. So we hear that a lot, but what exactly does that mean? From the 10,000-foot view, we're going to talk about duty, breach, causation, and damages, right? That's overarching what your attorney needs to prove to show that somebody else breached a contract towards you. And this is useful stuff for you to know because it will help you look at a contract through a different lens, right? So let's get started. I'm going to give you an example real quick, just an idea for us to go through the rest of this with. Say there's Jim and there's John. Jim is buying nails from John. He wants to buy 1,000 nails, right? Not the nails on your finger, hammering, right? Jim goes to John and says, hey, I'll buy these nails from you at $1 per nail. So that's $1,000. And so they get out their paper, they put together a contract, right? And it's important to note, contracts can be verbal, contracts can be from an email. Heck, you can write a contract on a napkin, right? So it doesn't have to be some long formal document. They decide that John is going to buy from Jim 1,000 nails at $1 a piece, and he's going to pay the money today, and he needs them in 7 days. And the reason why he needs them in 7 days, right? And this is all communicated, right? He needs them in 7 days because he's going to turn around and use those to make robots for another person, right? So he needs the nails. John needs them from Jim so he can make robots, right? He's going to put 10 of these nails into each robot, and he's going to sell these robots at $1,000 a piece. So if you do the math real quick, that means that he's putting these nails inside of the robot. 10 of them go in one robot and he's selling it for 1,000. So what do you do with 1,000 nails? You're able to make 100 robots, right? And these 100 robots you're going to sell at $1,000 a piece, which means that he can make $100,000. And all this is communicated from John to Jim. Let's say that he puts it in an email. These are important facts, that is, right? Now, we've laid the groundwork for what we're talking about here. All right. Earlier, I mentioned duty, breach, causation, and damages. Let's go with duty first. Duty is one person having a duty to another, right? This can be through law or through contract. And right now we're talking about contract. So in this contract, it says that John has to pay Jim $1 per nail, so $1,000, and he has to pay it today upon the creation of the contract, right? So he has a duty now, based off of that contract, to pay John $1,000. Let me write that down because it's Jim and John. All right, John is selling and Jim is buying, just so I don't forget. So Jim pays at that moment when they create this contract $1,000. He has fulfilled his duty. He had a duty based off of that contract to pay $1,000. And that's what he did. So now John, who has received this money, right? He now has a duty to deliver 1,000 nails within 7 days, right? And then he doesn't do it. If he did do it, then great. Contract's done. Everyone's happy. But if he didn't do it, he had a duty to deliver in 7 days, And absent any cure provisions and some other fancy stuff that we're not going to talk about right now, then he just dead set did not fulfill his promise, right? He said, you pay me today, I'll get you those nails in 7 days. And it did not happen. He has not fulfilled his duty, right? But we're not done. That's duty. You have a promise to do something, and it's either through law or in this case, because the contract said so. So Jim paid, John did not deliver, right? Next, we get to breach. Now, breach is pretty easy. Someone did not do what they were supposed to do, right? So in this scenario, Jim was supposed to pay, which he did. John was supposed to deliver. He did not. So because he did not fulfill his duty, he therefore breached his duty, right? That's it. He breached. He was supposed to do something and he didn't. Let's move on to causation. Causation goes together with damages at the same time, right? You had a duty, you did not do that duty, and that duty, which was breached, caused damages, right? So causation means that there's actual harm. In this scenario, the actual harm is Jim lost out on money, right? So what did Jim lose out on? Jim lost out on $1,000, right? Now you might say, that's easy. You can just give him back his $1,000. No, you're correct. And that will go a long way in this. But remember those extra facts. Jim told John, hey, I need these in 7 days so I can fulfill an order of 100 robots that I'm selling for $1,000 a piece. And now that John was late, Jim is missing out on that money, right? That is causation, a different form, a higher type of causation. But for, those are magic words in the realm of law, but for John not delivering, Jim would have found those nails somewhere else, or maybe not entered into that other contract, right? Jim was relying on John to his detriment. More magic words, right? Because Jim did not get the 1,000 nails from John, he could not fulfill his obligation and therefore get paid the 100,000 that he was supposed to by selling those 100 robots, right? So now Jim has claim for $1,000 that was paid and a claim for 100,000. Why is it 100,000? Because he was going to sell those robots, which needed 10 nails each. He's going to sell them for $1,000 a piece, 100 robots. And so he's missing out on $100,000. As a side note, reality, it would just be the profits that he would have got. So if the profits from selling those robots was $50,000, then that's what he would have been entitled to, plus his original $1,000. But for the sake of this, we're just going to say that it's $100,000, right? So now let's go to damages. Let's tie causation and damages together. If you have damages, you've got to say what type of damages, right? And there's different types. There's regular economic damages, which means this is money out of my pocket. Then there's benefit of the bargain damages. There's a lot of different types. There's special damages and punitive damages and all sorts of stuff, right? But let's not get too much into the weeds. The point of the matter is there's two types of damages here that Jim is entitled to from John. But for John's actions, Jim would have been able to recover $100,000 or get $100,000 from selling. So that is called benefit of the bargain. He no longer gets the benefit of the bargain, right? Oh, I'm sorry, lost profits, my bad. It's lost profits. But for John's breach and not doing his duty, Jim would have been able to sell 100 robots at $1,000 a piece. Now Jim is losing out on those profits. That's called lost profits. He wants to get the benefit of the bargain and have his nails to make his robots, to sell his robots, to then make $100,000. And because John knew about it, Jim let him know. They probably even put it in the contract, let's say, right? Jim has now relied on John to his detriment and is now entitled to damages. So tying it all together real briefly, you've got duty made from a contract. I'm going to give you $1,000. You're going to give me 1,000 nails, right? You've got breach. I paid you the money. You didn't give me the nails. You've breached it. You didn't give it to me in 7 days like you said, right? Causation. You caused my harm. You caused my damages by not breaching. And this is important because just say for a moment that John delivered him those 1,000 nails, but he delivered the nails, and when he was leaving, he knocked over one of his machines that's used to make robots, and everything fell over, and now Jim is late. There wouldn't be any breach of contract because John did what he was supposed to do, but there'd be another claim that Jim has. Let's not get into that. But the point of the matter is it has to fit the elements. Duty, breach, causation, right? But for John delivering those nails or not delivering those nails, Jim would have gotten the nails, made the robots, sold the robots, and bam, he would have made $100,000. And so that's how John damaged Jim. That's it in a nutshell. Now, there's a lot of things to talk about that it's the reason why lawyers are lawyers. Like, not everything is as simple as what I've given you. I've given you a very controlled scenario here, right? But the devil's in the details. It's the reason why lawyers go back and forth 1,000,001 times about a contract, right? There are things to worry about, especially if things go badly. There's venue provisions. There's choice of law provisions. There's cure, what type of cure provisions. There's what type of notice provisions, right? And then there's just general rights, roles, and responsibilities to one another, the parties of the contract, right? All of these things matter, and it can get real dense real quick. Not to mention that based off of the circumstance and the facts at play, then case law comes into play. And case law might be different in Texas than it is somewhere else, right? And so a simple breach of contract can become very complex very quickly in all sorts of matters. Lending, purchasing a home, commercial real estate, buying services, buying goods, you name it, renting a car, you name it, contracts and the words in them matter. But I've given you a very broad, controlled overview of what breach of contract is, and I hope that's helpful. So that's all I've got for you today. Please subscribe and follow. We're on all the platforms with the exception of Snapchat. I'll see you next time.